Welcome back. This is Daybreak, and thank you for staying with us. The hashtag on X is Daybreak. The SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadir. We begin with the development from the county of Uasin Gishu yesterday, where after striking on Sunday a conciliatory tone and called for the three arms of the government to work in hand, the president yesterday renewed his call and the allegations of bribe-taking in the judiciary and vowing to deal with what he termed as corrupt judges whom he accused of having teamed up with his opponents to sabotage his projects, including the pet ones that his administration outlined, and that to that effect the housing project and the universal healthcare coverage, in which he accused the third arm of the government as the delaying factor, and also calling out litigants. This is what the president said, and this sets up our discussion.
We have no time to waste. There is no room for delay. There is no room for sabotage. This program is not stoppable. This program is unstoppable.
Na hatutakubali kamwe mtu mmoja, wawili, watatu ambayo wanaongozwa na biashara isiyo halali wasimamishe kazi, na wakicheza tutapita na wao.
Tuzungushe tu hapa na sijui maneno ya porojo ya bure. Kwanza, hii program ya housing ilikuwa katika mpango ya 2017. Hiyo program ya universal health coverage ilikuwa katika mpango yetu ya 2017. Wakakuja wakatuletea kisirani. Sijui nini, salamu, sijui handshake, BBI, reggae. Mimi kitu yote ikaharibika.
Bob Mukange is an advocate of the High Court. Good morning. Happy New Year.
Happy New Year.
Thanks for making time for the broadcast.
Thank you.
The Law Society of Kenya President Eric Theuri is with us in studio, an advocate of the High Court as well. Thank you.
Thank you, Ayub.
Much appreciated. Honorable Farah Malim is the lawmaker representing the Dadaab constituency and a lawyer to that matter also. Thanks for your time as well.
Thank you.
Well, I first begin with you, Bob, and this in effect to some of the anticipated modus operandi of our governance in coming up with the Constitution 2010 and the vast array of independent institutions that were born out of it to that effect. What do you make of the language of politicians in regards to, we'll come to the question of corruption, the integrity of the judges and any other state of issue for that matter, but what do you make of the languages of politicians and, for example, what Alice Wahome just said on that soundbite we played, that tutapita na hawa?
Well, first of all, thank you very much and Happy New Year to you and to your viewers. And just to make a correction, that I'm not an advocate of the High Court of Kenya right now. I'm a lawyer, yes, right now in private consultancy. But with the president here, I'll be remiss if I continue with the show, holding on to that professional title and qualification. Okay. So let me set off the ball rolling from that point. I think it's unfortunate when we hear of such sentiments, and especially expressed with such ferocity, callousness, and I dare to say uncouthness. And within the context of who is saying this, as you've rightly put it, when a cabinet secretary, and when you see how Kenyans designed this office of the cabinet secretary, and that's why we've had age-long debates around the role of a cabinet secretary, as thought as to how the previous dispensation where we had the cabinet ministers was, where the cabinet minister was both an active politician in terms of competitive electoral politics and a member of parliament, and as well as a cabinet member. But Kenyans changed that with a viewpoint and with the wish that owing to the experience they had seen between 1963 and 2010, where when you had a mongrel of a cabinet minister and a member of parliament, they felt that this design was not efficiently and effectively delivering services to them from the point of the executive. They disambiguated this role. They separated the role of the member of parliament essentially from that of the cabinet secretary. And there are different reasons. And as I was saying, when you look at the debate, when you look at the views that Kenyans presented, and especially to the Yashpal Gai-led Constitution of Kenya Review Commission between 2000 and 2005, and also the work that we took over as a committee of experts, there's this nomenclature of a technocrat, of a person who, once appointed as a cabinet secretary, concentrates in rhetoric, in conduct, and in the wherewithal that the Constitution presents to this office, that the office holder concentrates on the technical aspects of the portfolio he or she has been given, and ceases to behave in the way and the light that we used to see before 2010, where somebody would be in Nairobi between Monday and Thursday and then go and issue such rhetoric in the villages over the weekend.
Outside declarations.
Yes. The second part of it is that is an outright threat. You know, when you tell people tutapita na nyinyi, we know what mtaani, what that means. If I tell you out in the streets, tutapita na wewe, that is an outright threat. And so it is very unfortunate to hear such sentiments coming from a senior state officer and of the caliber of a cabinet secretary. And when you think, and as I said, when you look at how Kenyans conceived the role of a cabinet secretary. So I think this rhetoric, these threats, this type of debating and deliberating about issues does not assist anyone, does not assist any Kenyan, does not assist the government, does not help us move forward. We cannot, you know, it is unfortunate that last year we had we were on the hot calls of political behavior and climate and context of Kenya. Yes. And we thought that a Christmas break will give us some time to excel, to reflect, and we start 2024 on a better note. But I think we have started on a hotter note, and you know, coming from the government, which is the leader of the direction that the country takes. So if it comes out blazing and adding or stoking the fires, then it is unfortunate for the country and for wananchi who want to settle down. Schools reopened yesterday, so most offices also reopened yesterday. People want to go on working, and if we start with this sort of language, threats, where are we heading as a country? So it's quite unfortunate.
Thank you. Honorable Farah Maalim, coming to you, and to quote the president, he said the courts are supposed to serve Kenyans equally, which is supposed to be the case. Judicial officers are public employees, and I assure you that I will deal firmly and decisively with corruption in the courts. He said that yesterday in Uasin Gishu County. And our current dispensation, the head of state has no prosecutorial powers, but there is a provided for mechanism to present all these allegations that he has raised of bribe-taking of judges before the Judicial Service Commission, a complaint against any judicial official, which was not done by the government. It therefore qualifies to use the wordings of the Chief Justice. Is it that this is not more than hot air?
I have my convictions on the matter that's basically in debate right now. What you have to understand is that judges have a security of tenure. They're there for the longest. The executive is there, and there's a right of recall every 5 years. Parliamentarians are also elected every 5 years. You call them the independent arms of the state. The independent arms of the state is that none of them has the powers to overload on the others. The other one, the executive, the judiciary, and parliament itself. We actually got ourselves into such a difficult position. There is a lot that you better have an element of dictatorship than have a situation of anarchy. You know what I mean? I mean, the state failures come out of anarchy when everybody thinks he can lord over everybody else. So when you say that independence, the independence itself means everybody is independent in executing their role. if you, these are my good, what they call legal minds. If you remember very well on the issue of Marbury versus Madison, which is one of the celebrated classical cases there, the remedy was there, everything was there. But because Jefferson refused to sign, they refused to sign. So the Chief Justice said, we cannot give orders to the president. You can't give orders to the president. So when the government comes up with its own projects and programs, they are there because they sold these programs and projects to the country for them to be given this opportunity to lead this country. You cannot have another institution which determines whether this project rightfully goes into that place or not.
You mean the manifesto that they sold the people?
The manifesto that is sold, and exactly what governance is about is there to execute, to implement projects, to allocate resources, to push all these things. So you can't have another body that says, no, you can't allocate the resources here. You get my point? So I see a rogue judiciary, to be very honest with you. Whether corruption is right, what they call rife in the judiciary, everybody knows.
Okay.
It's easier to buy a judge than to do anything else.
Okay. But Honorable Farah Maalim, good point that you raised there. However, when a manifesto is sold, all manifestos, be it that of Kenya Kwanza, what Azimio sold the people, the mandate accorded to Kenya Kwanza, these are variables. What's constant is the Constitution of Kenya, to which the president has the primary mandate of fidelity to the law. He was sworn into office and given the Constitution.
Absolutely.
That manifesto, therefore, is outweighed by the Constitution. Therefore, is it not important to be in compliance with the Constitution if you are concerned about corruption or any other issue that you have against the judiciary? Why not easily make your policies in compliance with the law?
You see, the corruption is a matter that essentially when somebody makes a claim, there's going to be a way to prove it one way or the other. Judiciary is corrupt to the bones. We all know that ourselves. And when you went there through petitions and everything else, you understand it. It happens in such a flagrant, outright way. If I had the opportunity myself, I would have put too many people under prison, because then I would have tapped their telephones, I would have followed it up as a pure executive, what do you call investigative process in which the intelligence, as well as the DCI, the Director of Security of what do you call criminal investigation, would try to bring all these things to stop all these things, because they happen. They happen everywhere. So there's a way to try and follow up on these things, and I don't think the government did use that. Because nobody is allowed to engage in corruption. Nobody is allowed to sell cases. You get my point? Nobody is allowed to be in the tech. And I know of a case myself, a petition case, in which somebody was paid close to 100 million shillings and said, even if I'm going to get sacked tomorrow, I have enough to go out there. And the judge goes out there and gives, what do you call, determines those cases in a manner you cannot understand. Go to the Supreme Court, for example. You remember the petition of the governor of Wajir, where, Supreme Court says, you look like you have a degree. And the evidence is full, massive evidence is here, including the man appearing before a parliamentary commission when he was a parliamentary committee, when the person was supposed to... Vetted for ambassadorial, in which he says he does not have any of those qualifications. And the matter itself that is at the highest apex of the apex court. You understand my point? So we have a rotten judiciary the same way we have rotten many other institutions in this country. Let me just finish. Let me just finish.
Please.
You see, I can see the frustrations on the part of the executive. I have a similar frustration myself, because there are programs and projects that I'm getting implemented in my constituency. And any crook who used to, plug himself into that and used to make money out of it would go to the courts, and you hear the courts giving orders and saying, conservative orders, stop these things, you cannot do this project. Now, for how long? These people do not have the luxury of time. They have 5 years to prove to Kenyans all the infrastructural development that they have to do. And if you don't allow them, we have 5 years as members of parliament to bring in as many laws as possible. I'm just looking at the totality and the philosophy behind some of these things that are happening right now. You don't see anywhere very, very limited cases in which the judiciary, whether it's in the common law, in the Westminster system, or even in the American presidential system, the peer executive system, where they are always after the government, telling the government you can't do that. For example, I'll tell you, there is a massive, what do you call, a difference between Republicans and Democrats when they come to power on matters of energy. Republicans don't care about the environment. They will want to go in and drill for oil or for energy in the seas, in the shores, and everywhere. But you see, nobody can stop them from doing that. The courts cannot come to them and tell them, no, you cannot go and drill for energy in the shows because of this environmental and this kind of things. Instead, they wait for the people to pass the judgments of them and make sure that they lose in the next elections. The right of recall, you are accountable as an executive to the government, to the people of the day. You were elected by the people. You sold your manifesto there. You have a limited time to go and implement on those manifestos. You don't have the luxury of courts coming in, you stop this, orders this, orders that.
They are not just coming in, Honorable Farah Maalim, as a lawyer. Courts of law, courts of evidence, and they rule and determine cases.
No.
You see, on evidence presented.
You see, let me tell you.
Okay, anyway, go on. This. Allow me to bring in the Law Society of Kenya president. And you have made critical submissions in regards to the millions of shillings you said a judge had taken. But as a lawyer and as a lawmaker to that effect, I expected you to file petitions before.
Well, you can do that, but let me tell you one thing.
Yeah.
Let me tell you one thing. They protect one another's back.
How about the case of Said?
Just a moment. Oh, what did happen to Said Machitembe?
Okay.
Is people went in there, bugged him. If that evidence was not there in which somebody went in there and tapped him, he would not have been taken to. The matter would have been over. His own judiciary would have protected him. But here was, the evidence that you cannot rebut. How many people can do that? How many ordinary Kenyans can go walk into a judge and do all these things and again get that kind of evidence on tape? You see what I mean? Nobody. But one thing is that, you see, by denying what is happening right now in our system, I do understand there's corruption everywhere. There's corruption in the legislature, there's corruption in the judiciary, there's corruption in the executive. There's no doubt about that. But for God's sake, the least we expected is the judiciary to be corrupt, because that is the final arbiter. And that's where we have to go.
Okay.
But the fact that the judiciary is corrupt, ask me. Okay. I have seen it myself, because I tried to get a lot of remedies in there and I've seen what happened.
Thank you. We'll take a look at the latest report by the Ethics and Anti-Corruption Commission, which ranks institutions of government when it comes to corruption. Mr. President, the Law Society of Kenya, thank you for your time. There seems to be a concern, and this is largely on the three arms of government and the clear blue water between the arms of government, which ought not to be violated. But the head of state is raising serious concerns about bribe taking, and also has concerns about the litigation process, which is a right provided for under the Constitution. Not once, not twice, but we'll look at the specific articles. But what do you make of now the government through two parliamentary committees now wanting to go ahead with the public participation process of the housing levy, which is the new bill 2023, yet there is a conservatory order issued by the High Courts in Kisumu and in Vihiga?
Ayub, we find ourselves in a very interesting place. The challenge we are all trying to grapple with is, what is the complaint by the executive? Is the complaint by the executive that we have a rogue and corrupt judiciary, or is the complaint by the executive that critical government projects are being stopped?
Yeah.
And that's why we are having a problem, because if you look at housing levy, there was an attempt to, before the act was enacted, to have a discussion between us and the government agency that is responsible for implementing the housing levy. Mm-hmm. And we told them two things. One, the manner in which they were proposing to go and enact the housing levy was clearly unconstitutional. Two, that they needed a foundational law to establish the housing levy. Three, that if they proceed in the manner in which they are proceeding, it will be discriminatory. We gave those submissions in the parliamentary committee. We had those discussions with the Ministry of Housing, with the PS, and I think there was even an attempt to invite us to State House, but we said even if we go to State House, we will still tell them that this law is unconstitutional unless they do 1, 2, 3, which they did not. We went to the High Court. We raised the similar arguments. The High Court agreed with us on those points. What has the legislature done, or the executive done? It has now come up with a bill to correct the things that we told them prior to the enactment of the Finance Act, which may then be said to be a good thing, because then we will have the opportunity to interrogate the framework that they have come with to see whether it agrees with the law or not. So then that's where, for me, I have a problem. Because even before we went to court, they knew what the position is. Now they are doing the right thing, so let's leave it at that. And you see the problem we're having is that they are implementing the High Court decision by coming up with a bill, but they are going to the Court of Appeal to seek stay. So what is the intention here? The intention here is to ensure that there is no integram in the 4 billion that is being collected. So that you go, and that's why I'm having a problem with government. You go, you get a stay, then you pass an act in Parliament when you have a stay order, so that once you have passed the act in Parliament, you are able to say that now we are going to leave the Finance Act legislation, because that is already being challenged and there's a stay in the Court of Appeal, and continue with the new act that would have been passed, and assuming, of course, obviously it would be passed. And that's the mischief on the part of government. It's an actual clear abuse of court process. So what is the president doing to ensure that he gets his stay in the Court of Appeal so that there is no break in the collection of the housing levy? He is coming out guns blazing, accusing the judiciary of corruption. And why is it easy to accuse the judiciary of corruption? Because every institution in this country is corrupt. So if I come and I make an allegation that Mheshimiwa Farah here is corrupt, I do not need to prove it, because in the court of public opinion, people believe the institution to be corrupt. So that is what actually the president is doing. He is bullying the judiciary to give him an order of stay pending the hearing and determination of the case in the Court of Appeal. Yet, they have already started action to implement what the High Court told them is wrong with the law. What we told them is wrong with the law at the point when they enacted it. If they had listened to us, we would not be in the position, perhaps, we would not have been in the position that we are in right now. And that's why we have a problem with what the president is doing, because we can see he is intimidating and bullying the judiciary to give him what he wants.
And there's a culture of bullying, if you look at the pattern back even in the previous administration, when, especially to pick out one of the major sticking point here, which is the nullification of President Kenyatta's re-election in 2017, where judges of the High Court were called crooks, Newakora, then you had the president, then Uhuru Kenyatta, his deputy, then William Ruto, now president, and also the litany of even name-calling of judges by their ethnic belonging, and also a call by a ranking member of the current administration, who is a lawmaker and chairs a critical parliamentary committee, who even called for the suspension of the entire constitution, saying that President Kenyatta can rule with an iron fist because the Supreme Court just simply disagreed with their submissions, the submissions made by the lawyers of the government then.
We don't have to go that far. In the case of Mumias Sugar, the president threatened all those who have cases against Mumias Sugar to withdraw them. I know advocates who were harassed, who were intimidated. Every time they were coming or going out of the country, they would be stopped for no reasons. I know advocates who were threatened, and they got to a point where we had to make arrangements for them to be put in protective custody because they were concerned about their safety, and they all had to file notices of withdrawal of those cases that were in court. So we don't have to go very far into in this current administration. We have seen the executive abusing his authority to settle cases that are before court. So we don't have to go very far. It is a pattern that we have already seen, and that's where the concern is. So on the fight against corruption, I think that is something that we should sustain in a very credible, objective manner, because and I want to agree with Mheshimiwa here, that one of the critical attributes about a judiciary is not only independence, but accountability. That if you have judges who are then independent and are not accountable, they become rogues. And so to that extent, we ought to sustain the fight against corruption. We ought to be not to leave any stones unturned.
Okay.
Whenever there are allegations of corruption, and not just corruption, but also incompetence on the part of the judiciary.
Thank you.
But we should never get to that level where we now say that we will go publicly, lynch the judiciary.
Yeah.
In fact, the entire institution of the judiciary, because we know that there are extremely good judges and judicial officers who are exercising the functions of their office.
Yes.
In a manner as contemplated under the Constitution. So let us deal with a few rogue ones.
Okay, extensively, Bob, after the break, and Honorable Farah Malim, I'll come to you direct, because again, there's the Judicial Service Commission, which is at the epicenter of all this. There's the question about the integrity of the judges. Of course, we are not denying there's no corruption in the judiciary, but the manner in which this is playing out in the court of public opinion is what's raising concerns, and also how we can embolden our institutions and deepen our democratic credentials. This is Daybreak. The hashtag on X is Daybreak. The SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadir. The discussion continues after the break here on the broadcast. Stay tuned.